The proceeding will start shortly. The proceeding will start shortly. The proceeding will start shortly.
Welcome to the Home Affairs Select Committee. This session is one of our regular accountability sessions with the Home Secretary to look at the work of the Home Office. So, first of all, Home Secretary, can I welcome you to the committee and congratulate you on your appointment at the end of last year. We haven't seen you since you were appointed, so many congratulations on that. And we're also very pleased to have the Permanent Secretary with us today and Mr Hobbs as well. We've got lots of questions, as you can imagine, this morning. I just wanted to start off just dealing with a couple of outstanding issues from previous appearances by the Permanent Secretary and Ministers before Christmas. So before Christmas, we as a committee asked for the information on the Bibby Stockholm and the value for money assessment that had been carried out. And I just wanted to thank you, Sir Matthew, for through last night the letter about the value for money assessment. I wondered, it's quite a short letter that you sent through, and it was promised that we would have something by the end of January, so we're just within time, so we're very pleased about that. Is there anything you want to add to what you've put in that letter? Because it is quite limited and doesn't go into very much detail.
Well, thank you, Chair. I mean, first of all, as I say in that letter, I keep the judgment under constant review about the value for money for that site and indeed other sites. And the variables that make up the judgment about value for money do fluctuate. The biggest thing that fluctuates, well, there are several things that fluctuate. First of all, the cost per person per night of hotels, which is what we are comparing these other sites with, and the number of people in the accommodation, for instance. So we'll keep it under constant review and very happy to keep this committee and the Public Accounts Committee updated if there are any changes.
Right, okay. Obviously we visited Bibby Stockholm, so we saw that it's obviously not at capacity in terms of the number of people who are living on the barge. Would you be willing to share with us, share with the committee your accounting officer assessment of the value for money of the barge?
Well, that's what I've shared is based on the value for money assessment and sort of sets out the conclusion of the work. And,
yes. We see the actual assessment though, because what you've sent us is very limited.
I think the crucial thing is the judgment about whether it's value for money or not, and the workings that is based on are summarised in the letter.
So you're saying we can't see the assessment?
Well, we can take away the request, but I've said that we would normally set these things out in the normal way. We wouldn't normally set out the full accounting officer assessment. We would.
I'm asking you because there's so little information. I'm asking to see the actual document that's behind the very short letter that you sent to us. So, I mean, we will formally write and request that. As a select committee, we can request documents from the Home Office. So
absolutely.
I think we will do that. Okay, thank you very much. And then the other issue I just wanted to check with you about was the letter of the 12th of January. Now, this came from the junior ministers in the Home Office, and it was in relation to the 17,000 cases that had been withdrawn as part of the Clearing the Legacy backlog. I just wondered if, I don't know if Mr Hobbs might just be able to help us on this. We're still not clear how many of the 17,000 that were withdrawn were from the Home Office withdrawing or from the actual asylum seeker withdrawing the claim. Are you able to just break that 17,000 down for us?
So I think so. Yes, thank you, Chair. I think the letter breaks down. These are withdrawals by the Home Office in response to the process that we go through when we were clearing the legacy backlog, to where we wrote to people if they did not respond, that then their case is then closed. I would have to go away and verify exactly whether any of those in that 17,000, because I don't have that figure in front of me, were withdrawals by the individual. But what will have happened is where the Home Office withdraws it is after us writing to the individuals and seeking to get contact either to them or their representatives. If there was no response
I think we were under the impression that there were people who'd withdrawn their claims within that 17,000, but it sounds from what you're saying...
My understanding is these are ones that we did
withdrawn
because of non-response, but
okay.
I will verify that.
Yeah, that would be helpful. And could I also just ask you, in that letter as well, there's reference to the 35% of the 17,000 that are now back in the system. Are you able just to tell us how many have been reinstated and how many are fresh asylum claims?
So, of the 35, they will be at various different stages. I don't have the full breakdown in front of me. Some we will do our best. As I say, some will be actioned for removal and therefore they're engaged in other parts. So where we've re-engaged with them, some will be with immigration enforcement, some will be further submissions. Obviously, they will all be further to their initial claim that had been withdrawn.
Yeah, we just want to be clear about how many have been resubmitted and how many have been reinstated. And then just finally, on the final figure of the 2,643, so this is those who remain in the United Kingdom and have re-engaged and have been granted some form of lawful immigration status. Are you just able to tell us how many have granted asylum or humanitarian?
I don't have that figure in front of me.
Could you let us know that as well? That would be very helpful. Okay, and are you able just to tell us what the final quarter figures were in terms of withdrawals? Because the 17,000 were up until the end of September, I think the 30th of September last year. So there must have been more withdrawals since. You able to give us that figure?
So I think the last formal published stats were September, and that's the figures that we have available.
Right.
Obviously, we announced in December the full clearance subject to the unworkable cases, but I don't have an update on the withdrawal stats until the published stats come out later.
When are they due to be published?
I think it's February is the next instalment of
February
stats normally.
Right, okay, well we're particularly interested in the withdrawals that took place in that final period leading up to the end of the year. Right, thank you very much for that, that's very helpful. Can I now turn back to the Home Secretary? And I'd just like to start by asking you some questions about violence against women and girls. And I was very struck with your comment in recent weeks that tackling violence against women and girls is a personal priority to me. I think that's quoting you directly. And I wanted first of all to ask you about concern that's arisen about the way our crime statistics are reported. So I noted last week the Home Office and yourself actually tweeted out that violent crime is falling. Since 2010, violent crime is down 51%. I just wanted to check with you. Obviously, the basket of violent crimes that's used by the Crime Survey of England and Wales doesn't include things that I think a reasonable person would say they would expect to be in there. So rape isn't included, sexual assault isn't, stalking isn't. And now we know those disproportionately affect women and girls. So I just wondered, are you concerned at all about how those offences, which we know are actually going up, that the public may be not clear that what's being tweeted out is actually correct for those particular offences?
Look, I mean, this is a really important question about the definitions of what falls within or without certain baskets of crime, and there is always a challenge about using consistent metrics, so you can compare with previous periods, but conscious that those metrics might not always capture everything that people might assume. And that is a challenge because, as you say, I think a lot of people would look at rape, for example, and say, well, obviously that fits within the violent crime basket. I think the decision was made to compare like for like, because if you're comparing over a period of time, you have to stick with that. Conscious that every definition is imperfect, so that's why we did that, so we can compare like for like. And then with a lot of those hidden harm type crimes, domestic violence, child sexual exploitation, rape, for example, where we know there has been very, very long-standing underreporting. I am very, very focused on dealing with that. But in terms of comparing longitudinally, the consistency, I think, provides more value than constantly trying to amend.
Yes, I can understand that. I think, though, that it would be very helpful, because we know the government has a commitment to tackling male violence against women and girls, if we could have some attention paid to that group of offences that disproportionately affect
I can
women
assure
and
you
girls.
we are very focused on those.
Okay,
I can absolutely assure you we're very focused on
Right.
those.
So at the moment, those come out as an annual statistic, as I understand, and I think some attention to that would be very helpful from the Home Office in highlighting what's actually happening with those figures. Can I just move on now to the Domestic Abuse Commissioner, who last week on those same statistics that were published, she was raising concerns about the downplaying of the scale of domestic abuse due to the principal crime rule, which is that only one crime, the most serious offence, is counted for every report by a victim, even if multiple crimes are taking place. So the stats last week, there was 23,000 fewer recorded crimes of domestic abuse compared to the same quarter in the previous year. Do you worry about that? Do you take on board what the Domestic Abuse Commissioner is saying?
I understand the point very much. And again, it's one of these things about the trade-off between consistency so that long-term comparisons can be made, and granularity, and there is always a trade-off there. And I think the point that's made is very much a valid one.
I think take it away and have a look at it, because I think that's genuinely of concern to the committee.
Yeah, but there is of course a potential risk in terms of redefining things.
Well, you've redefined it because of the principal crime rules. That's the problem, I think, that the Domestic Abuse Commissioner is concerned about.
Yeah, but I can absolutely assure you that the message that I have conveyed both within the department right from the get-go, with senior police leaders, PCCs, and I'll be reinforcing this when I'm at the National Policing Board later, is that this is absolutely a priority. It's one of the priorities that I put for the department. Okay. But I'm very conscious that measuring it has always been a problem. Really difficult.
Yeah, no, I agree with you, and I think the Domestic Abuse Commissioner wants to make sure that we're all fully aware of the level of domestic abuse in this country. It's not hidden away.
Absolutely.
Can I just ask you, excuse me, something else the Domestic Abuse Commissioner has called for, and that's a firewall between the police and immigration enforcement to protect women with insecure immigration status who come forward to report domestic abuse or sexual or violence generally. Now, this committee has also called for that firewall. Are you sympathetic to that? Do you think that's a good thing that should happen?
I understand the argument. I'm not yet convinced by that argument. In my experience, not just in sexual violence, domestic abuse and other such crime types, but typically been a lack of data sharing that's caused more problems than data sharing. I could envisage circumstances where an abuser games the system in order to hide their abuse towards a victim. I could see how that plays out.
I think it's more the woman not feeling confident about reporting to the police. That's the issue, because it may result in immigration action being taken against her. So we want to encourage women to report, don't we? That's the key thing.
Yeah, and as I say, I think there is a credible argument to that end. I think there are also credible counter arguments. It is a really difficult situation, as is often the case.
Okay, so the Domestic Abuse Commissioner and the committee, and I think others have called for this. So perhaps that's something you could take away and have.
And sometimes, just because I or the department might not agree doesn't mean to say that we're not taking those suggestions very, very seriously. And of course, we will always look at the best way of protecting victims, particularly, as I say, women and girls, because I have prioritised this. And so if I'm saying no at the moment, please don't read that as me saying that it will definitely always be a no. But I am absolutely committed to looking at this, but making sure that whatever decision we make support women and girls.
Okay, just a couple of other things. In our latest report on trafficking, we made a recommendation that the penalty for a man paying for sex with a trafficking victim should be increased from a fine, as it currently is, to a penalty comparable with other sexual and trafficking offences, and increase, obviously, the deterrent value. Do you agree with that?
Again, I think that's a very credible argument. In terms of the sentencing, that would be something that we would need to work with Ministry of Justice
But in principle,
about. Look, I think it's a very strong argument. Again, I'm not going to make policy at a committee, but again, I mean, it is a strong argument, particularly in terms of an aggravating factor potentially in other crimes, or toughening the sentences. I think that makes a lot of sense. As I say, that's more in the remit of the Ministry of Justice than
okay,
the,
but obviously it's
department.
trafficking, and we know that the government take trafficking and modern slavery very seriously, and would want to do everything they could to protect particularly the most vulnerable, and women who are sexually exploited seem to me a group that you want to put some attention on. My final questions are just around Parliament last year under the Public Order Act. Now this is around safe access zones. We specifically voted against proposals to allow silent prayer and consensual communication in safe access zones. And I noticed that the Home Office have produced guidance which includes those measures being allowed. And I just wondered why you would do that when Parliament had been very clear that that wasn't the will of Parliament.
So the draft guidance that went out is draft guidance for consultation. So that's not the final guidance. When I stepped into this role, when I was being briefed into a range of things, the fact that the consultation to follow up on that parliamentary vote, on that decision by Parliament, had not yet been actioned, and it had been delayed quite a long way. And I was presented with a choice, which was to revisit the draft guidance, put it through right round and go through that cross-Whitehall process, which would have added to the delay, or initiate the consultation with the draft guidance that I inherited.
Right.
I decided that I wanted to get moving on this because the delay had been far too long already.
Okay.
I would say, and I've said this to people who've lobbied me directly, the draft guidance is just that. It's draft guidance.
Okay.
The final guidance will, and I don't want to speculate as to exactly what that will be, but the final guidance will be based on the feedback that we've had from the consultation. The consultation is important, and obviously we're very conscious to make sure that the expressed will of Parliament is reflected in the ultimate guidance that is put out. That's
reassuring to know. So, for example, there were proposals in that guidance to put up signs around premises where there was a safe access zones. And I think there's a great deal of worry that that's not appropriate in dealing with the confidentiality and well-being of women who are accessing abortion services. So it sounds to me from what you're saying, you're rethinking actually what was in that draft guidance, because it doesn't sound fit for purpose.
Look, I don't want to prejudice the process, but the point I have made is that we are listening very, very carefully to the voices that are coming back through the consultation, that have contacted the department directly, and also, of course, the conversations that were had through the passage in Parliament. And all those will be listened to very, very carefully before we finalise anything.
That's great, thank you. I'm going to now come to James Daly.
Thank you very much, Home Secretary. Home Secretary, I'm quoting from the Rape Crisis England and Wales website, and it says the following: 68,109 rapes were recorded by police between July 2022 and June 2023. By the end of that 12-month period, charges have been brought in just 2.2% of cases. That's 1,498. Now, I just wonder why you think charges have been brought in so few cases. Now, it's obviously, we can't talk about individual cases, but it's a very small amount, isn't it?
It is, and that worries me enormously. The first visit that I conducted as Home Secretary was to Holborn Police Station, and I spoke to the investigatory team that were looking specifically at violence against women, sexual violence cases. Spoke with them about about best practice. I've spoken with the College of Policing about making sure that investigators follow best practice, and there is some quite a range of performance across police forces, and I want to make sure we get them all to the upper end of the spectrum. I mean, that you will know, the committee will know, that prosecuting sexual offences is very, very difficult. Often, the victims are traumatised to the extent that they don't come forward promptly. There's a whole load of reasons, but there is best practice. We want to pursue that best practice, and that's a conversation again I'll be having with police leaders throughout.
Well, one of the grave concerns for me in respect to this, and I put this to your predecessors, is that the real problem within the system, I mean there's lots of problems with the system, but one of the major ones is the fact that police do not refer cases to the Crown Prosecution Service. So something is happening at that initial investigation stage where legal advice is not even being sought. And I just wondered whether you had the chance to speak to police about that, senior police officers, to ask why that is the case and why such a large number of cases are not being referred even for consideration by the CPS.
Look, I've not asked that question. I've made an assertion, or not made an assertion. I've given an instruction, which I think kind of reflects the point that underpins your question. And the instruction that I've given is that we have got to do better. That there are examples of say best practice. There are examples where the good process, better processing, better training of officers, the better administration of cases increases the likelihood of success. If we could get all forces to absorb that learning and implement that learning, I think we would see a step in the right direction. And that's a conversation, as I say, I've had from literally first day in the job, and I will be reinforcing that both through the internal priorities which I've published for the Home Office and will be circulated around the Home Office, and the conversations that I have with police and crime commissioners and police leaders and the College of Policing.
I just want to ask two further questions regarding charge-out rates. Now, we don't have time to go into figures, but charge-out rates for many offences are extremely low. And one of the things I suggest that may be at the heart of that is the relationship between the police and the Crown Prosecution Service. Now, I don't know whether either of those organisations have spoken to you about this particular situation, but I know there is a real concern from the police that the Crown Prosecution Service are requiring, I can't think of a sort of slam dunk cases that unless you have 100% of the evidence and there is a 100% chance of conviction, and I'm exaggerating a point, but I don't think it is completely out of order, then a charge is not going to be forthcoming for all range of offences. And I just wonder whether that is something that's been brought to your attention and whether you have any thoughts on that.
I think case preparation is key, and increasing the likelihood of the CPS progressing a case with a strong evidence pack is absolutely key. This is Operation Soteria, which is the mechanism by which improvements in this have been driven through a number of police forces. I think has helped case preparation, which has then the positive knock-on effect of increasing the likelihood of the CPS taking that up. I've not had the chance to speak with. I've not had the chance to speak either directly with the CPS or via the Ministry of Justice with regard to the CPS. Of course, CPS guard their independence in terms of the prosecuting decisions, I think, very strongly. I totally respect that and understand that. I want to make sure that the bit of the system that the Home Office has most influence over is really, really maximised, and that's making sure that the professionalism of rape and sexual crimes, the investigations are as professional as possible, the case preparation is as consistent, and as professional as possible. And that's something, as I say, we're driving through with Soteria, the College of Policing, and it has demonstrated improvement. So I want to maximise that, and I think there is a conversation well worth having with the CPS as well.
And last question from me. Just ignore if it's a first-time offender. If somebody is arrested for shoplifting, should they be charged and put before a court? Not first-time offenders, should everyone else?
Well, we've made the point that all reasonable lines of inquiries should be pursued. I'm uncomfortable giving a blanket. I think this should be happening, but I also think it's very, very important that everybody deserves the right to work in a safe environment. I think shoplifting is a crime. I think when shop workers try to intervene and protect themselves, they do put themselves at risk. So it's something that the police and prosecutors should take seriously. And I've had conversations with senior leaders across UK policing to say that it is a highly visible crime. It's corrosive when it comes to public confidence. We have got explicit instructions that every reasonable line of inquiry should be pursued, and that very, very much includes retail crime.
Thank you very much.
Thank you. Can I just ask, as someone newly in post, were you surprised that not all police forces have a specialist unit to deal with rape and sexual offences? Because that as a committee is something we are very struck by, that not all 43 police forces have that in place when we know that's what works.
Surprised a bit. I mean, I can understand the arguments. I'm not necessarily saying I'm agreeing with the arguments. I think one of the challenges, particularly with smaller forces, is about the practicalities of having specialist teams, particularly in some of the smaller and more geographically dispersed police forces. I get the challenge. I'm not saying I agree, but I get the challenge. The point with Soteria is that it takes a lot of the guesswork out of how to improve this. There is established and proven ways of working, and specialist teams seem to be an important part of that. Now, as the Home Secretary, I'm not in a position where I can mandate police forces with regard to their structures. As I say, I have seen, even with the short time that I've been in this role, evidence that those kind of specialist teams make a positive difference.
Yeah, I think we agree with you on that. We're just surprised that not all police forces have adopted that. Diane Abbott.
Thank you, Chair. I wanted to ask a few questions about the Bibby Stockholm, because I think, as you know, we visited it a few weeks ago, and it was a very interesting visit. The first thing I wanted to ask is about space. We saw the rooms where the men are supposed to sleep. These were rooms intended for one person, and they now hold two people in bunk beds. I spoke to one man who said that he found it also cramped, that he was sleeping on a sofa in one of the common areas. I just wanted to ask you, you're absolutely confident that the space available to detainees in their rooms on Bibby Stockholm meets legal requirements as to space?
Oh, I'm totally confident it meets legal requirements, yeah.
And the other question I wanted to ask you related to the recent suicide on the Bibby Stockholm. I understand that the inquest and so on is still going on, but talking to some of the other detainees, they said that for some days before he committed suicide, he was talking about suicide, he was banging on the walls and shouting, and of course it's all been very alarming for them. Are you confident that anybody who was suicidal on Bibby Stockholm would get the mental health support that they need?
So we take both the physical and mental health of the people who are in the asylum estate very, very seriously. I'm not comfortable discussing the circumstances around this particular case because, as you say, there is the coroner is looking into this, and I wouldn't want to in any way accidentally prejudice the outcome of that. But we do take both physical and mental health very, very seriously. We recognise that that's an important duty that we need to discharge.
I'm not asking you to discuss a particular case. I'm asking you, are you confident that anybody on the Bibby Stockholm, bearing in mind the very confined space that they're in and issues around medical care, are you confident that anybody in the Bibby Stockholm who was suicidal would get the mental health support they need? Speaking specifically about that.
Well, by virtue of the fact that there's this case outstanding, we need to look at this seriously. I mean, the sad truth is that we recognise there is suicide risk, and there's suicide risk in any number of circumstances in society, and that is something we take seriously. Of course, once the findings of this case are made public, we will look very, very carefully at any findings and recommendations that are made. But we do take mental health, as I say, very, very seriously. We will always take opportunities to learn, and if there are things that need to change, we'll of course listen to that. But the point is that, as I say, without seeing without seeing the report from the coroner, I don't know if there's any specific learnings. I don't know whether that was avoidable or not.
You've answered quite a specific question in general terms, but maybe I'll come back to it. Thank you, Chair.
Thank you.
Well, no, I mean, I'm quite happy. I'm quite happy, to try and clarify further. But as I say, I've been, as you know, I've been a member of the Reserve Forces, I've been a member of the Armed Forces. By the nature of the work the Home Office does, we work very closely with the Ministry of Justice in circumstances all across society, particularly where you have numbers of people accommodated in one place. The risk of suicide is something you take very, very seriously, and sadly, suicides do happen. We always take our response to that seriously. So we will listen very, very carefully to any findings that the coroner makes, and if changes need to be made, of course we will look at any recommendations. But I'm not going to speak in the specifics of this particular case, so by definition I can only speak in generalities.
As you know, we have visited the Bibby Stockholm and you haven't, but we are going to write, together with our colleagues on the Joint Committee on Human Rights, raising further questions about conditions.
Okay, thank you.
Thank you. Tim Lawton.
Thank you, Chair. Before I come to the Home Secretary, could I just pick up with the Home Secretary where the Chair left off? Home Secretary, you recall, I'm sure, your visit. We're here with Mr. Ridley in November when he was the interim second PUS, I think. So I don't know if he's still interim or now permanent. And it ended rather unsatisfactorily with him admitting that the Home Office did not know the whereabouts of those 17,316 withdrawn asylum applications. Since when you've provided us a letter with a little more information, and Mr. Hobbs has offered to go away to find out more, what's quite basic information about the nature of those withdrawals. So I gather figures we're giving that of those 17,3144 have left the UK, 2,643 have had some form of immigration status granted, which is fewer than a third. So do we now know what's happened to the remainders who have no legal basis on which to still be in the United Kingdom?
Yes, we do, Mr. Lawton, and the Minister set that out, I think, in a letter to the committee. So there is that category of people where we have re-engaged with them, they've rather re-engaged with us, and they have been granted some form of immigration status. Mr. Hobbs was talking about that category. There are three other categories of people. There is the category of people who have already left the UK and so have therefore sort of definitively left their asylum claim behind. That's 3,144. Then there's a category of people whose cases are being managed by different parts of the Home Office system, including immigration enforcement, appeals, litigation team, and so on. And then finally, there is a group, 5,598, who do remain in the UK, and the Home Office, through our different mechanisms of tracing people, are continuing to seek to trace them.
So, not that we're asking for an individual list, but if there were a list of 17,316 names, you could put a location against, be it out of the country or a location in the country, against how many of those names now?
We can tell you exactly, as we did in that letter, how many have left the country, 3,144. Right. Of the people who are in the country, they are not detained. So we cannot pinpoint a precise location, but for the vast majority we have contact details, and we use those contact details to seek to re-establish contact with them if they are in that final category of people who we have not yet re-established contact with, but we are seeking to do that, and that is the group that, as I say, we have the ministers have set out in a bit of detail the different ways that we have of seeking those people, but we're not going to go into more detail on that because those methods need to remain private.
So some of them are not subject to reporting requirements.
I think they were all subject to reporting requirements and breached their reporting requirements, which is what initiated the process that led to the withdrawal of their claim.
So a large chunk of them may still not have reported, and you may still not know where they are. Unless or you may not know that you don't know where they are because you've not instigated trying to make contact with them again.
So in that category, we have instigated trying to make contact with them again. That's precisely the definition of that category, and we have not yet succeeded in re-establishing active direct contact with them, and there's no automaticity about that because they are not detained. But we are using all of the different efforts of tracing them to seek to trace them.
I'm trying to define how many of that 17,316 are effectively still unaccountable for.
5598.
5,598. You do not know where they are, and they've failed to respond to attempts to make contact with them.
Yeah.
And what is the status of those people who have come across the Channel since the Illegal Migration Act came into force? How many of them are there, and what is their actual status?
Their status is they're claiming asylum, and they are in different stages of the asylum caseload.
Under the terms of the Illegal Migration Act, they're not entitled to apply for asylum, are they?
They're entitled to apply, but then they are. Then we have a different process under that act for dealing with their claims.
Well, they're not entitled to apply under the terms of the Act, so they can apply, but that application is not recognised within the normal asylum procedures. Correct? So what is their status?
Their status is that they have sought to claim asylum, and we are continuing to manage they are in the asylum caseload.
But they aren't. But they can't. They're not recognised as asylum seekers. So how are they in the asylum caseload?
So, if I may, they are inadmissible, as you say, Mr. Lawton, to our system. As you know, at the moment, we do not have a safe country of return for the vast majority of those individuals. So they are here on bail, pending the conclusion of the Safety of Rwanda Bill and then the movement forward of our relocation agreement with Rwanda. So they are inadmissible to the system under the terms of the Illegal Migration Act. If they would otherwise be destitute, we provide support to those individuals, but they will be pending the further stages of the inadmissibility procedure, which are set out in the Illegal Migration Act.
So how many people are we talking about now?
So my understanding is the last published stats on the 28th of December, those arriving since the Illegal Migration Act are 33,085.
Right, so we have 33,085 people in the country, all of whom have been bailed?
Unless there's other mitigating circumstances or risk then yes, they would be bailed because our ability
What's
to detain.
an other mitigating circumstance?
So in case, for example, if someone were identified as a foreign national offender or a previous immigration offender, there may be a basis on which to detain them. But as you know, the general principle for immigration detention is that you can only detain where you have a realistic prospect
How many are
of
detained?
removal. I don't know of that cohort how many are detained.
Okay. How many of the 33,085 do you think you could contact?
So, I can't give you a direct percentage, but a number of them will be in accommodation. All of them are expected to report on, depending on the individual regime, and many will be accommodated by the Home Office in various asylum support accommodation if they would otherwise be destitute.
How frequently do they have to report and to whom?
It will depend on the individual circumstances and the nature, whether that's face-to-face, whether that's telephone reporting or e-reporting. It will depend on the individual case.
Why should
and that's
there
a matter for an
why are there
operations.
differential requirements for reporting of somebody under the terms of the new Act?
It's not because of are set depending on the circumstances of the individual case, the person's previous, what we may know about them previously, whether they're part of a family group, and that's an operational decision that's taken depending on the assessment of those cases.
Okay, do you know how many people that you've tried to contact or have been subject to reporting mechanisms which they have breached out of that 33,085?
I don't have those figures in front of me
Okay.
about non-compliance.
So, Home Secretary, welcome.
Thank you.
Are you satisfied that we could have a number of people which is roughly double the earlier queried cohort of 17,000, a number of whom we don't know where they are? They have no legal status to be in this country under the terms of the Illegal Migration Act, other than those who have criminal records that require them to be detained in a secure facility. They are at large in the UK and could turn out to be missing on a greater scale than Mr. Ridley was unable to account for back in November.
I don't agree with the word missing. I think that word implies something which doesn't reflect the circumstances. But I mean, the point is, of course, I'm not comfortable with many of the numbers that were discussed, which is why I've just come back from France, working with our French counterparts to try and end people arriving on small boats, reduce illegal migration coming to the UK in its totality. So I'm not comfortable with a lot of the figures that we're discussing. We're doing something about it. In terms of asylum seekers or people in this cohort that we're discussing. I mean, to attempt to do so would be incredibly costly, would dwarf the cost of our hotel accommodation, which we're reducing, for example. And of course, we make the point that non-compliance has consequences. We've increased the number of illegal raids, we've increased the amount of immigration enforcement work that we do. So when people do disengage, and I think that's a more accurate word than gone missing, when people do disengage from us, we respond to that. As Matthew has said, I'm not going to go into detail of how exactly we do that, because that will undermine the operational effectiveness of the work that we do. But we do go looking for people. When we find them, if we're able to return them to their country of origin, we do so. And as you know, through the Safety Rwanda Bill, we're making plans to be able to remove people who don't have a safe country.
What I'm concerned about is that there is a growing cohort of people in limbo, effectively, since the new Act came in, who, other than those with a criminal record and set circumstances, are not in secure accommodation. And notwithstanding the authorities trying to keep contact with them on whatever reporting mechanism they may have, there is let's say, a fairly strong possibility that we do not know where a large number of them are, which is another definition to me of missing. That figure can only grow in the absence of the Rwanda scheme getting underway or us having other deportation agreements with other countries, as we hope we're going to have. But I'm a little confused at how that 33,000 figure is made up, because that figure is since, Mr Hobbs will have the date, whenever the Act came into...
July was the
20th of July, yeah, okay. So the figures we had for the whole of 2023 of people coming across the Channel, and this cohort will be primarily those people who've come in little boats, not exclusively, but primarily. And that figure was just under 30,000. So how is that figure 33,085 for the second half of less than the second half of the year? Where have all the others come from who didn't come across in little boats then to constitute that figure, Mr Hobbs?
So, as you say, the Illegal Migration Act covers all illegal entry. It is not just targeted at small boats, so it will affect other people who have arrived in the UK without lawful status or able to demonstrate that they had lawful status in the country. So the Illegal Migration Act applies to all of those individuals,
Great.
not just small boats arrivals. So it may be people who have arrived on a fraudulent visa, have arrived on other fraudulent documents, or in other modes of arrival clandestinely into the UK and then have come to the attention of our immigration services.
So what is the other big form of clandestine arrival? Because if you arrive, if you try to get on a plane without the requisite visa, you shouldn't be allowed on the plane. Some people can with fraudulent documents. I understand that. There are some people, although hopefully it's much more difficult, as we've seen on the other side of the Channel, to get on the back of a lorry. So what constitutes most of the non-little boat people out of that 33,085?
So there'll be a range of ways in which people enter the UK without compliance with immigration rules and services. It's probably not wise for me to set all of those modes out in public to the committee. But as you say, some will come through various ferry ports, some will arrive at our airports either with fraudulent documents or not having the appropriate visa or believed to be having gained that visa fraudulently. That doesn't mean the visa itself is a fraud, but they may have undertaken fraud in gaining that visa. We also have the common travel area where we do see movement across between the Republic of Ireland and the United Kingdom. But there are a range of ways in which that can happen.
Okay.
And with regard to our response to this, I mean, you do make a good point with regard to the Safety of Rwanda Bill. So that is an important part of it. But one of the things I've said over and over again, that is one of, but not the only response to this. So in terms of negotiating returns agreements with countries, that's something that in my former role as Foreign Secretary, I know the Foreign Commonwealth and Development Office was heavily involved with negotiating that, which increases the number of countries to whom we can safely return people because those countries are safe and we have mechanisms for returns. And we can see the impact of that. So Albania is not the only country with which we do this, but it is a really good example of how effective it can be.
And I think many of us will agree with that. Can I come just on something different, Home Secretary? David Neal, the Chief Inspector of Borders and Migration, why is his contract not being renewed?
Sorry.
David Neal, the Chief Inspector of Borders and Migration, why is his contract not being renewed?
I'm not sure I can answer that at this point. Can I look into that and come back? There may be a reason that I can't share. It may well be. I don't want to speculate on that. I'd rather know for certain.
I think the committee is concerned because we've had him in front of our committee on many occasions, and I think we've been very impressed with the work he's done. What we've not been impressed with is the attitude of the Home Office to his report. So as it stands, I gather, 10 reports he has produced have yet to be published by the Home Office, some going back some way, and 11 reports that he has had published are still awaiting response from the Home Office. The attitude of the Home Office in not taking those reports sufficiently important.
So I've met with David. We had a meeting last week before. And we discussed the responses to the reports he's put forward. And a number of responses will be forthcoming. So this is something that the department is addressing. The point I said to him in the meeting, the work he does is important. We do take it seriously. and ensuring that we do respond in a timely manner. I know this is something that the chair of the committee has raised with me, and something that I do take seriously, not just as a professional courtesy, but I mean, I joke. I can't remember whether I mentioned it to you. I jokingly said that sessions like this are like a trip to the dentist. We can all pretend that we enjoy that. We really don't, but we also recognise it is quite important. So this is a conversation I have had with David, and we will be. I will be ensuring that we respond where necessary and appropriate.
Okay, well, we're not going to put you through root canal surgery, but certainly to use a dental list of other reports and reviews that have been commissioned by Home Secretaries going back several years to the beginning of this government that have not seen the light of day, just not been responded to. And it seems an extraordinary waste of time and resources to commission review that then never gets published. We had complaints from Sarah Khan when she was here, some very important points she made in her report that were relevant to inquiries we've had, and they've just not been published. On David Neal, this committee requested to help our work and to respond to an invitation from David Neal, that committee members should be able to go out on an inspection with him of one of the premises he's entitled to inspect, to see how he goes about his inspections, which I think would help our work. In front of the committee, the former Home Secretary thought that seemed a good idea. The Immigration Minister didn't see any objection to it. And then the formal request was turned down by the Home Office. Do you know why? Do you think that was the right decision? And if not, will you review it?
It's an interesting point. I mean, it is complete within David's right to invite the committee to look at his work. I don't think it is.
He had to get the permission of the Home Office, so it's not within his right to invite and execute.
No, I was going to come on to this. So he can invite the committee to see what he does. I'm not sure it is necessarily automatically appropriate for him to invite the committee onto one of our facilities. It's the Home Office facilities, and there is a difference. Now, ultimately, I know the committee recently visited the Bibby Stockholm. We had discussions about the logistics around that, and my views on the best way that I can balance openness to the committee with my responsibilities to both the service users and the operators of those facilities. And whilst not perfect, the feedback I have had, my understanding is that the committee did have access to the service users, and that you were able to have meaningful conversations with them, and I think we resolved that in a successful way.
We don't have a complaint about that. It's actually going out with the inspector to see how he does his work, to see whether we think he's being rigorous enough, for example. So allowing us to judge the nature of his reports when they're eventually published. And the ministers did not have an objection.
Yeah.
We then questioned the Permanent Secretary as to why this was not allowed, and were told it was a ministerial decision.
Right.
So if it was a ministerial decision, why did it change from publicly yes to privately no? Or if it wasn't a ministerial decision, as your Permanent Secretary claimed, whose decision was it and why?
Well, I have no doubt if one of my officials said it was a decision made by ministers, it would have been a decision made by ministers. And as I say, the situation with David's work is that by definition, his work is done in our facilities. And therefore, ensuring as I said with the trip to the Bibby Stockholm, ensuring that we balance our desire for visibility of our work is important, but so is making sure that is in keeping with the other responsibilities that I have in terms of the Secretary of State responsible for these things. I think that balancing act can be navigated, as we had with the Bibby Stockholm. What I'm not going to do is give a blanket assurance that David can invite you as a committee onto our facilities. I'm sure that we are able to have a pragmatic conversation, negotiation about making it work, as we did with the Bibby Stockholm, which I think worked.
That would be helpful.
Mr. Loughton, if I may, just to clarify, that the 30,000 number I gave you is all asylum claims since the Illegal Migration Act had royal assent. So some of those will fall under the 4 conditions, potentially, but we haven't commenced the duty to remove. So I don't have the division between how many of those may fall under the new provisions of the Illegal Migration Act and therefore subject to the duty to remove. The number I gave you was the total number of asylum claims since the 20th of July.
I think what we need is to know those people primarily, but not exclusively, came over in little boats, which makes
the numbers
them
of small
not
boats
liable.
are published separately. Obviously, because we haven't commenced the duty to remove yet, we won't have made a conclusive decision about all of those cases, about whether they do or do not fall under the 4 conditions of the Act, because we're not in a position to make those yet until the Act is that those provisions of the Act are commenced.
But if somebody comes across on a little boat since the Act came into force in July, they are automatically excluded from making a processable asylum claim.
You have to demonstrate they meet the 4 conditions that are set out in the Act. That's a requirement under the Act. That provision hasn't been commenced yet. So,
what scenario could somebody coming across the channel today still be able to make a legitimate asylum claim?
So there are the conditions set out in the Act that we have to demonstrate that apply to those individuals, including mistaken identity or findings of fact, that there are requirements under that Act. In principle, the Act is aimed at individuals who arrive illegally in the UK who don't have leave, but there are requirements under the Act that we have to demonstrate that they meet those 4 conditions to fall under the duty to
I understand
remove.
the 4 conditions, but what could possibly qualify somebody coming across in a small boat that they do not come within the 4 conditions and can therefore have an asylum application considered?
So it may not be the asylum application, but it may be other things. So again, as I say, there are safeguards that were in the Act passed by Parliament that mean that we do have to go through that process to determine that they definitely meet those conditions. It could be that somebody does have leave, for example. There are lots of hypothetical situations that may apply, but as I said, that the number I gave you is people who've claimed asylum since the Act. It's not necessarily...
Very likely that somebody with leave to remain or a visa to come to the UK is going to pay a people smuggler to come across in a dinghy, is it?
I agree, it's hypothetical, but as I say, what we have to do is
ridiculously
we have to meet by the law and demonstrate they meet the conditions that are set out in the Act, and that procedure hasn't begun because we haven't commenced it.
Unlikelihood does not give us licence to ignore the law.
Okay, just on this 33,085, they are part of the flow backlog, or are they a separate backlog?
Separate backlog.
They are part of the 94,000 asylum caseload.
You're keeping them all together in one flow backlog, even though this 33,000 actually, at the moment, we think can't apply for asylum.
So they are counted in our total caseload of work that is in our system.
Right, so 94,000 is the current backlog.
It's the caseload.
The caseload. Okay, so that's different from the backlog because...
It's not. I mean, these are the cases that we're working through at the moment. The backlog was specific. So at the time of the change of legislation, there were a number of outstanding cases. We committed to give an initial decision on those, and with the exception of the small number, which I know the committee has commented upon.
Well, that's the legacy backlog.
Yeah.
Yeah. So we put that to one side because you say you've completed that. I know there are some concerns that isn't the case, but you say they've done that.
Yeah.
But you've still got a backlog of claims post June 2022. So that is now at 94,000. Is that what you're saying to me? That's the backlog of asylum claims you are working through.
Caseload is 94,062.
94,062.
And that includes claims since the Illegal Migration Act.
Right, so that's the total number now of who is in the backlog, but we've recognised from...
I'm telling you, keep describing it as a backlog.
But it's not a backlog. I'm sorry, I don't understand why it's not a backlog.
It's the case. I mean...
Why is it not a backlog? Because you haven't dealt with them and people are waiting. Why is that not a backlog?
Well, it's a queue.
It's a queue.
No, the point is, you can apply. I think your use of the word backlog implies something that I disagree with, and that's why I highlight the point. There are a number of cases that we are working through. At any given time, someone who has arrived will be added to the caseload.
Yeah.
By your definition, if someone arrived yesterday, that would be a backlog.
Yeah.
And I don't agree with that as a definition. So the phrase that we use, and obviously the committee is at liberty to use whatever descriptor you wish to use, but that is our caseload that we are working through.
Right. So when do you think you'll get to the point where somebody arriving today will have their claim dealt with within the 6 months that you used to do in the Home Office? You used to process claims within 6 months. So this 94,062 queue backlog caseload, when are you going to get to the point where you're dealing with things quickly and we're not going to have to talk about backlogs?
Well, what we saw last year, because of an increase in the number of people.
I understand that. I'm just conscious other people have got questions. I just want to know, have you got a date in your mind when you will have
It's impossible to give. It's impossible to give a complete date. But the point is that we
did it for the legacy backlog. The Prime Minister promised, didn't he, by the end of last year he'd clear the legacy backlog. So I just wondered if you were of a similar mind that you were going to get this.
Well, I want to do it as soon as as soon as we're able to, as soon as possible. We've got an increased number of people, and we have a faster system.
We understand.
Which is why we're able to deal with the backlog, and we are working quickly through this.
Right, I'm going to come to Carolyn Harris, but just before I do, one other question on the 33,085 that are recognised now within the scope of the Illegal Migration Act. How many are you expecting to send to Rwanda?
Well, that will depend on which other countries we have returns agreements with.
You haven't got any at the moment, so Rwanda's the only safe country that you're obviously processing through.
No, Rwanda's not the only safe country. The point is there are other safe countries. We're negotiating. We have negotiated. We continue to negotiate returns agreements with other countries. So it's entirely feasible that those. A significant number within that cohort will be returned to their country of origin.
Okay, but what do you expect in terms of the numbers to Rwanda? Because that's your flagship policy. You're pushing this through the Commons and the Lords. How many of that 33,000 are you expecting will go to Rwanda?
It depends on which other countries we send them to. So the point with Rwanda is that it is part of our response, but only one part. And in parallel with the Safety of Rwanda Bill and the treaty and the work we're doing in Rwanda, we're also doing work with other countries.
Okay, but just setting aside those other countries.
But why would we set aside those other countries?
Because you must know at the moment, in terms of the 33,000, which countries you can then send those people to, potentially, because there's a list.
Yeah.
But what I'm asking you is, those people who cannot be returned, say if they've come from, I guess, Afghanistan or Syria or various other countries. So they are the ones who are going to go to Rwanda. Out of that 33,000, how many, when you get that first plane, which you've talked about wanting to take off as soon as possible, how many are you sending to Rwanda of that 33,000?
Well, I'm sorry. So firstly, the Rwanda scheme is an uncapped scheme.
Yes.
So there's no inherent upper limit within that cohort of who we could send to Rwanda.
So how many do you think?
But again, it's not a figure I can give you because we are negotiating returns agreements with other countries. As those returns agreements come on stream, the number of people who can't be returned to their country of origin will reduce. That will have an impact on the number of people that we might send to Rwanda. So you're asking me to speculate about a figure. Which no one can give you that figure because, as I say, if you'd asked me this before we came to the arrangement with Albania, the answer would be very, very, very different to the point that we now have a returns agreement with Albania. We're working on returns agreements with other countries that can have a very significant impact on the quantum of people that we might consider going to Rwanda. And because the Rwanda scheme is uncapped, these would be entirely speculative figures.
Okay, but with the greatest respect, Home Secretary, Parliament is going through the process of putting into place the legislation you need around the Safety of Rwanda Bill. Sure. We're told that the government and the Prime Minister, they want to get this done. Yep. I'm assuming that in place are various operational procedures and you're getting people lined up and you've got perhaps an airline, because last time Minister was here, we didn't have an airline that could remove people. So I'm assuming all this is being planned because you're a department of that has lots of people doing lots of planning. Yeah. So all I'm trying to work out is, what is the plan in terms of dealing with this 33,000? What are you expecting? Is it 100, 1,000, 10,000? What's the plan?
With respect, you keep asking me the same question. The answer is therefore going to be the same. No, that's not what I'm saying at all. That's what I'm saying.
We're not getting an answer. I think that's the problem.
You're asking for a figure that no one can provide because it is contingent on other things happening. No.
You can't answer it if you can't give me a figure.
I am answering. No.
I think you're repeating. I understand what
you're
saying.
You're repeating the question
because I'm not getting the answer, which is.
No, the answer is.
Move on. I think.
The answer is it is entirely dependent on
returns.
what other work that we do. So you're asking me to speculate, but the answer is entirely dependent on other work we're doing in parallel. So it may well be that if we are successful with returns agreements, if we're able to stabilise, if circumstances in other countries change, it may well be that the figure could be quite low. Yeah. It could be nearly at that figure, but the point is that the figures, the number of people that we might send to Rwanda is entirely contingent on a whole set of other work that we are doing.
Thank you.
But the point is there is no cap to the
we
scheme.
understand there's no cap. I'm just trying to get a sense of how many would go. But Carolyn Harris.
Thank you, Chair. Home Secretary, it would seem that one of your own backbenchers is not very convinced of the Rwanda plan. Robert Jenrick has said the government... There will be many more. Robert Jenrick has said the government is only planning to get a few symbolic flights off before a general election. How many flights would it take for it not to be symbolic?
Well, I disagree with him. I respect Rob enormously, but I just fundamentally disagree with him on this. Because so what he describes, perhaps as symbolic, the word that I wouldn't use, is reflecting the fact this is meant to be a deterrent. So I wouldn't use the word symbolism or symbolic. It needs to have visibility. It needs to be seen. Part of the reason why we're negotiating, the treaty with Rwanda and we're getting the bill through Parliament, is to visibly send the signal to people that are putting money in the hands of people smugglers, putting their own lives at risk in order to finish their journey in the UK, that you will not be successful finishing your journey in the UK. So the visibility is actually an important part of the deterrent. And we do want to send the signal that if you come here illegally, you will not stay here. You'll either be returned to your own country if it's safe, and that's why we're negotiating return agreements, or to Rwanda if it is not safe. But the broad point, we want to send the message. He calls it symbolic. I would call it a deterrent.
Well, I'll leave Mr. Jenrick to follow up on that one with you. I want to talk about pimping websites.
Yeah, sure.
Something you probably would be prepared for me to be asking about pimping websites. I'm really concerned that you can't put an advert in a phone box advertising sex for sale, but you can advertise on a pimping website. And we know from the inquiry that we've done that there are some individuals whose telephone number is across very many different profiles, not because they are the individual person selling the sex, but because they are a trafficker who's selling women. Now, I did bring this up with one of your ministers very recently, and her reluctance to consider doing anything about this was that because some people prefer to sell themselves online and therefore may have multiple profiles, that we would be denying them the opportunity to sell themselves if we were to take action to prevent this happening. Surely you wouldn't agree with that thinking, Home Secretary?
Well, I mean, the law around prostitution, the so-called sex industry is incredibly complicated.
Just say it's not an industry; it's exploitation.
Well, yeah, and this is why I'm trying to be very careful with my words. But the legal framework which we operate, I think, is a legitimate area for debate and discussion, and Parliament might be minded to change rules. And I just even in the short time that I've been Home Secretary, I've heard arguments and counter arguments. At the moment, we operate within the legal framework that we've got. We know that there is a significant risk for women because of the nature of these websites. We make it very, very clear to the people that own and operate these websites that they have a duty, not just a moral duty, but a legal duty, and that is underpinned by law, and that will be enforced. So officials in the department have interacted with the owners and operators of these websites to make it absolutely clear about their legal duty and our expectation for them to abide by that legal duty. And I'm very conscious of the risks that you highlight, and in terms of the law enforcement, both police forces and NCA, who are very, very focused on the protection of women, particularly protection of vulnerable women. They're very conscious of the role that these sites can play in that. As I say, a broader debate about the nature of what is and is not legal in this space, I think is completely legit, but at the moment we're working within the framework that we've got.
So you talk about the communication with the owners of the websites. Are you aware of a case where one person spent £25,000 advertising various women on a website? This gang had actually been found guilty of trafficking 11 young Romanian women from one end of the country to the other. And instead of that website contacting the police to inform them that there were red flags were here, they actually gave him his own account manager so that he could spend more money.
Well, look,
we are facilitating trafficking here.
And so, I mean, this is something. As I say, this is a risk that our law enforcement colleagues are very, very aware of. The details of that case, I'm not familiar with, but my view, and this is a view that I'm communicating within the department, is whether it's more generally illegal working, where people are being coerced into employment, whether it's sexual exploitation, whether it's modern slavery, particularly when it is directed towards women. My very, very clear expectation, my very, very clear instruction to all the organisations over which I have influence and control is that they are to prioritise this work. And as I say, there's a broader conversation about the legality around this, but my message is very, very clear. This is a priority, and I will be ensuring that the police, the crime agency, and the department respond to my prioritisation of this.
Well, maybe the chair and I could come and have a meeting with you to discuss the new clause we lay into the criminal justice bill at this very moment in time. Thank you. I now want to talk about serving police officers who have committed sexual offences. They are permitted to remain in work. Wouldn't it not be appropriate for them to be suspended from work pending the outcome of investigation so that we can ensure that they are not in contact with females? This is a successful, which I'm hugely supportive of, a campaign run by the Refugee charity. It's gaining momentum, and I just think it's something that the Home Secretary should be given some serious consideration to.
And thank you for raising this. When I was first elected onto the London Assembly, I served on the Metropolitan Police Authority, and I served on the Professional Standards Cases Subcommittee, which sounds like a bit of an innocuous backwater, but basically it was the committee that dealt with breaches of professional standards, sanctioned police officers, in a number of instances ejected them from the force, and did pension forfeitures. So I started my political career basically punishing misconduct in policing, and I have maintained a passion for it and an interest for it throughout. And again, in the conversation that I have with police leadership, I've made it very, very clear, and this has been reflected in the Criminal Justice Bill, that police leaders, both political and uniformed, have a duty to get a grip of the professional standards of their forces. We will back them in doing that, but we do expect them to do that. Now, again, it is important that when we come to things like suspensions, that the trigger for that is calibrated properly. I think there is a strong argument to say where there are allegations of sexual misconduct that should be taken very, very seriously. And I have a lot of sympathy for that. I do also think it's important that the system moves quickly. There are far too many officers who have been suspended for far too long, and they should either be cleared and get back to work, or the investigation should be completed promptly and the appropriate sanction made. So I'm uncomfortable with how many officers have been suspended for long periods of time. So I get the argument. I need to look at the detail. Again, I'm always uncomfortable making policy at a committee like this, but I will look very, very seriously at the proposals that have been put forward, because I think it's absolutely right, particularly in light of circumstances like Sarah Everard and others, that we make it absolutely clear that the police have an enhanced duty to be, and seem to be, acting professionally, particularly in circumstances like this, and I want that rippling through UK policing, that right from the top we are watching and we demand action be taken.
I mean, just for the Home Secretary's reference, we have heard of a case where a serving police officer has been caught and actually prosecuted for masturbating on a tube, and is still a serving officer, which is quite horrific in my opinion. And my last question, you'll be glad to know, is around the definition of human trafficking as it is here and as it is in the UN. Now, we know, because our definition differs, there are cases in this country where we are placing women in danger. I say women, we've obviously placed men and young boys as well, but it's normally women we are placing into the hands of abusers, merely because the definition says that we have to transport them physically in a vehicle in order for them to be deemed as trafficked. Now, we both know that if we pass a human being from one lap to another, then that is effectively trafficking. But because our definition does not accept that, then we are actually handing vulnerable people into the hands of traffickers. Can we not look at this legislation, please, Home Secretary?
Again, I'm more than happy to look with a genuine open mind at the practicalities, and we touched upon it slightly earlier on with regard to definitions. It's rare that you can find a perfect definition, and I will look at any discrepancies between the definition that we use and other international definitions. I'd be uncomfortable saying that I'm definitely going to necessarily change it, but I'm more than happy to look at any, as I say, discrepancies between definitions that we use, definitions used by others, and if there have been instances where the difference between definitions is being exploited, and I'll look into that.
I appreciate that. Thank you, Home Secretary.
And I think, Home Secretary, there was a review of the Modern Slavery Act that the Home Office was undertaking, so it may be some of the work's already been done on this.
Okay.
There's also, Chair, the response to your committee's report on human trafficking, which is due on the 8th of February, which is next week. So
we look forward to receiving that in time. That sounds like we're going to get it in time.
Of course.
Of course. Oh, well, that's very good. Excellent. I'm just going to take Diane Abbott very quickly, and then I'm going to Simon Fell.
Before we leave Rwanda, I just had a question actually for Sir Matthew. You came before us in 2022, and at that point the scheme had been announced a few months earlier, and at that point you had requested a ministerial direction because you weren't prepared to say that the Migration Economic Development Partnership, Rwanda, had a strong financial evidence base. And you came before us and you said that you still didn't know whether the Rwanda scheme would provide value for money. You said the success of the scheme and whether it's a financial benefit will be determined by the numbers of people it deters from illegally crossing the channel. And you said you had no evidence of a deterrent effect so far. Do you have any evidence of deterrent effect so far? And do you still stick by your position of the spring of 2022 that you were not prepared to sign off the policy as value for money?
The ministerial direction remains in force, and it will do so unless and until I am able to make an affirmative judgment that the policy does have evidence that it is going to be value for money, and that judgment I keep under review, as I have said before, and I will come back to the committee if and when it changes. So far it hasn't changed. It'd be hard, I think, at this stage to have the positive evidence of the deterrent effect until it is fully operationalised. In other words, until once the flights are up and running.
Just that I'm clear, you're still saying that you don't have the evidence that the Rwanda policy is value for money. I just want to be clear, that's all.
What I'm saying is that for any policy, either there needs to be evidence that it's value for money or the relevant accounting officer needs a ministerial direction. It is absolutely clear that there needs to be a deterrent effect in order to stop people trafficking others across the channel and risking their lives. So the deterrent effect, as the Home Secretary has said, is a really important part of the total government response to the challenge of small boats and more broadly of illegal migration. And once the Rwanda bit of that policy is up and running, we will then have the evidence about whether it is providing deterrent effect. We know that deterrence works because we have the Albania.
Then it's different,
which is different. Absolutely, it is different, but it's similar in the sense that it is deterring people from making a crossing from that nationality, and so that's what we are working on the basis of. And as my letter requesting the direction made clear back in 2022, because of the scale of the challenge and the cost to the taxpayer of the status quo, it is reasonable for the government to seek innovative solutions, including the Rwanda policy.
Thank you very much, Chair.
Simon Fell.
Thank you, Chair. And just to put on the record, I was appointed as the anti-fraud champion back in December, so I report to the Home Secretary in that regard. I won't be asking any questions on fraud, but I just want to make that clear. Welcome, gentlemen. I would like to ask some questions about violence and abuse against retail workers, if I may, especially in light of the upcoming proposed smoke-free generation legislation and the ban on disposable vapes. 2 years ago, this committee produced a report into violence and abuse against retail workers. We made a number of recommendations. At the time, there were an estimated 455 incidents of violence a day against retail workers. The BRC now estimates that is sitting at about 850 incidents of violence against retail workers a day, 27% increase in shoplifting, and both the BRC and the Association of Convenience Stores estimate that this ban is going to increase the trajectory of travel there, unfortunately. So given the plans, what work is the Home Office doing to estimate the impact on retail workers, not just on those who are selling vapes and tobacco products, and what is the assessment of the impact that it's going to have on them?
Thank you. The increase in violence against retail workers is, of course, unacceptable. And it's something that I've discussed both with the Met Commissioner and other senior police leaders. So in terms of the impact of the ban on vapes, I don't have internal projections on that. Of course, we do listen carefully, and caveat by saying, listening carefully does not automatically mean we agree with the estimation, but I think it is a reasonable set of assumptions that underpin the work that the BRC have done. So we do take it seriously. There are a couple of things which focus specifically on retail. Obviously, it is an aggravating factor in any criminal charges, which I think is important. And also, our instructions to the police, they are to pursue all reasonable lines of inquiry, I feel will also have an impact, a positive impact on this. I think one of the problems that we have seen is the perception that shoplifting and retail crime will not be responded to by the police. I think that has emboldened certain criminals, and the perception by some that you can just do shoplifting and get away with it has meant that retail workers feel that they have to personally take action, and then we've had this nasty escalation spiral. So making it clear to the police and making it clear to retail workers that the police will take shoplifting seriously and will respond should give confidence to retail workers that they don't have to take action and therefore they can keep themselves safe, but also to the criminals and potential criminals that they will be pursued by the police in this. That should have a suppressive effect on that. I will look at the BRC's work with regard to the changes to the age limits for tobacco, and we'll feed that into any guidance the conversations that we have policing about this.
Thank you. And just to be clear then, so are you planning on issuing a directive that retail crime should be attended because the feedback I've got, I went on store visits in my own patch, and I've heard this through reports from the BRC and others, that actually a lot of shopkeepers feel that when they report to the police are just not attending. Clearly you've done this with burglaries and made it very clear that we expect police officers to attend where a burglary occurs. Are you expecting to do the same in the retail space?
Yeah, so as I say, I've had direct conversations about this, and the example that I've given, it's a bit like the broken windows principle. If the policing model that we have has a significant part of response, but also a really important deterrent. And if you lose the deterrent element, it makes policing infinitely harder. And I think the message we need to get across is that retail crime is a crime and will be taken seriously by the police and will be responded to by the police. And that, as I say, is both to reassure the people, the retail workers themselves, but also as a deterrent effect. So I've had that conversation directly. The thing with burglary, I think we're demonstrating it has a positive effect. And we will keep pushing on this all reasonable lines of inquiry instruction, and we'll keep pushing on it hard. And we will, and we have taken action. We have taken action with regard to police funding to support and prioritise things like town centre policing, hotspot policing, so that there is an increased presence in those retail areas, so that the police are able to respond promptly to retail crime and reverse what I fear has been a kind of an escalatory cycle.
Thank you. So one of the recommendations we made in 2022 was for a standalone statutory offence, capturing violence against retail workers. At the time, when the Home Office responded to our report, they rejected that proposal. I'm just wondering, in light of the clear escalation in violence we've seen and the estimated escalation following these proposals, are you going to look at that again?
So I have had discussions about the practicalities of this. As I say, I think so my instinct is that as legislators we tend to turn to legislation, and it's understandable that we seek to do so. I think a lot of what we're trying to achieve through that is being played out through the aggravating factor in terms of sentencing. But ultimately, whether it's a standalone crime or an aggravating factor, if the police aren't attending, if they're not investigating, it becomes a bit of a moot point. And so my instinct is fix the thing that needs fixing first. And whether it's whether it's an aggravating factor or a standalone crime, the police have got to be there, and they've got to be taking action. And if they're not doing that, anything behind that kind of falls away. So let's get the police on the streets, and we're providing funding for that, making it very, very clear of our parliamentary and government expectations of policing of retail. Let's get that. I think that will go a long way to addressing the issue. And if subsequently it is clear that we still need to give that more heft, then we do have that legislative response still available to us.
Thank you. And it's obviously not just about the legislative response, so there are other levers which the Home Office can pull here. Again, that report made recommendations around strengthening business crime partnerships with more direct Home Office funding, and also directing Safer Streets funding to especially smaller independent retailers who might not have the resilience and resources themselves to properly respond to the scale of the challenge. I'm just wondering what your thinking is in that space.
Yeah, well, I particularly, I owned and ran a small business for a while, so it wasn't a retail business, but I'm conscious that small privately owned businesses are less resilient to shocks, and the cost of retail crime has a disproportionate impact on the smaller retailers. I'm reminded that we published the Retail Crime Action Plan in October of last year, and that contains an explicit commitment from the police to prioritise the urgent attendance at retail crime. But you're absolutely right. I mean, the smaller retailers, they don't always have the money to put some of the physical defences that larger retailers have, and so it is incredibly important that we respond to that. And again, as part of the Retail Crime Action Plan, particularly with regard to violence, where someone has been apprehended, either by the retail workers or security guards, there is again a commitment from the police to respond promptly and to send the signal that that action will be taken. But as I say, a no isn't always a no, but I want to get this end of the system right first.
Yeah, thank you. And there's another challenge here, which is dealing with supply, especially illicit supply. So literally a couple of days ago, there was a policy paper published stubbing out the problem, which was a joint border force and HMRC paper looking at the illicit supply of tobacco, not vapes, which is estimated to be worth about £2.8 billion a year at the moment. I wonder whether you could talk us through what measures Border Force are putting in place to better identify where some of these products are coming into the country, how they're capturing the criminal gangs that are responsible for them, and stopping them entering the market in the first place.
Yeah, so you'll understand that there are certain operational things that I'm not going to go into because they are understandably important to keep discreet and secure. But I visited the National Crime Agency and looked at both the domestic and international work that we were doing to break smuggling gangs. We've talked about illegal migration earlier on today, and the sad truth is that for smuggling gangs, often people are just a product to be smuggled. And people that have historically smuggled drugs or narcotics or tobacco or alcohol have drifted into the business of smuggling people, and we're trying to break all those different smuggling operations, including the smuggling of people. I can reassure the committee that both the interagency working, so Border Force, HMRC, National Crime Agency, and our partners internationally are quite closely coordinated. Because whilst smuggling of illicit drugs is often thought of when people think of smuggling, actually smuggling things like counterfeit tobacco brands, tobacco, alcohol is actually a really significant part of the smuggling operation. And when I visited Luton Airport, it was Luton Airport, that's right. I visited Luton Airport just really before Christmas. Not only did I look at our returns flights, our repatriation flights, but I also looked at about 1 week's seizures of illicit narcotics, and it filled a room floor to ceiling. So this is a very real challenge. We're very alive to it. Again, I'm not going to go into details, but I can reassure the committee that there is close coordination both domestically between agencies and between UK agencies and their international counterparts.
Thank you. It's nothing if not a glamorous job, yours. Obviously the ink is barely dry on this report, but what it doesn't do is cover vapes. So I'm wondering whether there's going to be a duplicate or matching strategy to cover illicit flows of those as well. I think it's excuse me 1 second, the British Vape Trade Association says about a third of the vapes in the country at the moment are illicit products. One would expect that will grow again with the ban. So I'm assuming there will be some thinking on this and how
so I don't have any details for you at the moment, but as you say, this is although not new, it is a fast growing and I think not just with vapes but other non-combustible kind of tobacco and nicotine products. This is something that we are going to have to continue to work on. I think one of the advantages we've got is lots of the work that we're doing on other forms of smuggling and tobacco smuggling will probably be relatively easy to port across to non-tobacco products. Non-igniting products.
Thank you very much. Can I just pivot, if I may, Chair? I think this is probably for you, Mr. Hobbs. Could you talk us through the asylum accommodation and support contract and what the review process for those are? In particular, I'm looking at the induction paperwork provided to asylum seekers. The reason I raise this is I have a number of asylum seekers in my own constituency who have been handed pieces of paper which are essentially blank, missing support workers off them, missing details over how to contact their local council, given pieces of paper saying Google your local food bank. Clearly this is not meeting the standard that you would expect, and I'm sure are to the standard that the Home Office set. So what's the process for reviewing this and calling in the contractors who are responsible?
So, as with any contract, there's ongoing dialogue with the contractors, and there are certain standards that they're anticipated to meet, both in terms of the quality of the accommodation, fixing, repairs, and, as you say, in terms of migrant help and their support and direct. If you write to us, we'd definitely take up those considerations, and I'll pass it to the relevant team who deal with the contractor, because, as you say, it really is important that those requirements in providing clear information to those who we are accommodating are clear and supporting. So, as I say, it's standard contract management in terms of the requirements that are set on them. There is a regular dialogue both through the Home Office commercial team and the team that manage the asylum accommodation process. But very keen to take up those individual cases.
Thank you. I will definitely write to you. But just on the broad principle, if a company who is contracted to deliver these contracts consistently fails in their ability to meet what is a relatively low standard, which is simply fill in a form and hand it to someone, I assume that contract will be under review.
So obviously, without going into the individual details of the contract and the specific requirements, you are correct that we would obviously have a discussion with those contractors about their compliance with what is required of them, should there be evidence that they're not, or again in terms of our own ongoing evidence and assurance around those contracts.
I just add two things to what Mr. Hobson said. First of all, we have beefed up that part of the department, so there is more resource dealing with our contract management in this space because it is such a large contract, even bigger than we thought it would be when we signed it. And secondly, we do have examples of companies that have, not necessarily in this particular area, but in the Home Office's area, where we have had to use some sort of tougher and tougher measures. As Mr. Hobbs says, we start off by engaging with the company and ensuring that they know there's a gap between the level they're providing and what they should be providing, and then if they're still unable to close that gap, then of course there are measures within our contracts to claw back certain funding, and we have had to use that on some occasions.
So that can be termination of contracts.
And then after that, you would then get into termination of contract. Yeah.
Thank you very much.
Thank you. Alison Thewlis.
Thank you very much, Chair. I've got a number of slightly different areas of questioning for you, but to start with the situation on the Bibby Stockholm Home Secretary, can I ask what's your understanding of the criteria of why people were stuck, or why people were placed on the Bibby Stockholm?
Why certain?
Why particular people were based on the Bibby Stockholm?
The Bibby Stockholm is non-detained, so the first criteria is split between detained and non-detained. In terms of if there were more specific criteria, I might turn to my officials in terms of a tighter definition than that. But obviously, it is part of our desire to reduce the overall cost of asylum accommodation, and that's the overall reason why the Bibby Stockholm was commissioned. If there's any more detail as to why the individuals were placed there rather than one of the other forms, I might turn to you.
Just to add to what the Home Secretary said, so everyone coming into the system has an initial health check, an initial screening, and at that point the caseworkers who are trained specifically to do this do make assessments about whether there are any particular vulnerabilities, and on the basis of that assessment we then decide who goes where.
I ask this because one of the people that I spoke to on the Bibby Stockholm, well, several of the people that I spoke to on the Bibby Stockholm, didn't understand why out of an asylum population of over 120,000, this particular 300 were selected to go on this boat. Can you give any explanation for that?
Well, it's part of our accommodation. I mean, theoretically, you could go to any part of our accommodation and ask the same question, and the service users wouldn't automatically know why there rather than the next door town, or rather Bibby Stockholm rather than Wethersfield. I mean, I can understand from their point of view, but actually, it's part of our accommodation estate, and people are allocated.
Are they placed there by means of a deterrent to make it sound tougher than a hotel?
Well, the point is the hotel accommodation was a short-term measure in response to a significant increase in the requirement for accommodation. It was never envisaged to be a long-term solution. It has shown to be a very expensive way of doing it, and we are broadly moving away from hotel accommodation across the board. Our accommodation needs to absolutely meet the needs of the service users. It is not designed to be an incentive, and more broadly, we're looking to deter people from putting themselves into the hands of people smugglers, from risking their lives. So I think it's important that it meets the needs of the service users, and it does. But we wouldn't want any part of our accommodation estate to be viewed as some kind of incentive.
So the people that I spoke to certainly did not feel that it met their needs. So I would certainly dispute that as in the first instance. The people that I spoke to had been in hotels previously and then had been moved from those hotels away from their legal representatives and their support to a place where there are very few lawyers and legal support in that area because they don't have a history of migration, they don't have immigration lawyers in the vicinity. And they had not come over in small boats, either, the people that I'd spoken to. One of the people that I'd spoken to had come from Iran. He had been a student. The situation in Iran had changed, so he couldn't go back there. He couldn't afford his international student fees, so he had claimed asylum. that seems perfectly reasonable. There is no reason why he ought to be feeling that he is being punished, which is how he felt for that circumstance.
No one's being punished. So this is not a punishment. We need to accommodate asylum seekers. That accommodation needs to be functional. The Bibby Stockholm was designed to accommodate workers. It is not a punishment. None of our accommodation, including our detained accommodation, is a punishment, and it's really, really important that's the case. Now, of course, I completely understand that people might not necessarily like the accommodation that we are providing. I completely get that, but it is designed to be safe. It is designed to be functional, and and the criteria of who goes where is it's a byproduct of availability numbers and that kind of stuff. But as a general policy, we are moving away from accommodation in hotels because it distorts local economies. It is expensive for the government, and it is not the best use of public resource.
Do you appreciate why somebody who had been in a hotel, who was moved to the Bibby Stockholm without explanation, without much notice, and who doesn't know how long they will be on the Bibby Stockholm for, how they would be quite frustrated by that, how they would not understand why they were there, why that would feel like some kind of punishment?
I can understand that people, they might not understand the policy drivers that the decision we make at the Home Office. I completely understand that. Because
they seek a reason for why they're there, and they can't get that reason or for even how long they'll be there.
Well, the reason is quite simple. Is because they're applying for asylum. We have a duty to accommodate them during that process.
Specifically, why this 300 out of the 120,000 of population? They don't know why that is.
Well, but as I say, if you asked anyone in any part of our estate, they could give you the same answer. They would not know why they're being accommodated in Sheffield rather than Norwich, or the Bibby Stockholm rather than Wethersfield, or Wethersfield rather than Liverpool. It's not.
Some of the people on the boat that we spoke to have now been in the UK for well over a year. Mm. Why are they not being allowed to work?
Well, look, this is the policy with regards to the ability to work whilst seeking asylum is explicit. It's there. It's a long-standing policy. What we're looking to do is to focus on a system whereby the applications are processed in a speedy and timely way. As I say, we've had great success on that. We are looking to make sure that, successful or unsuccessful, asylum seekers know where they stand quickly.
Yeah, a year and 3-4 months is not speedily. That person should be entitled to apply for work after 6 months. Why is that not being permitted to the people in the Bibby Stockholm?
It's not after 6 months, after 12 months. After 12 months.
In shortage occupation lists, it's after 6 months.
Do you know if they have applied?
They have not been able to apply for that. They're not getting any answers from the Home Office, and they don't have a lawyer because they've moved them away from their lawyers. Well,
without being, it's always difficult to talk about individual cases. There may well be reasons. I'm not going to try and. So I'm a bit torn. So in order to respond to the detailed concerns that the individual raised with you, I would need to know the details of that individual, and I wouldn't want the committee or indeed the service users to feel that somehow an increased focus of attention was brought upon them that they didn't want to. So if that individual wants to get in contact with us to query part of their process or case, then of course we will look at that. But without knowing the details of the individuals, without validating, again, the simple truth of the matter is that there may be details that weren't disclosed to you. There may be other details that have an influence on the case. Without knowing those details, I can't really comment on individual cases, and extrapolating out from one individual across the entirety of the people we're currently accommodating, I just don't think is a useful exercise.
And everyone should have access to legal representation. So if there is a particular case where that's not the case, if you would let us know, then we will follow them up separately.
Immigration lawyers anywhere in the vicinity. It makes it very difficult to seek immigration advice, and to have 300 people seeking what limited immigration advice that exists locally is almost impossible.
Well, we have to accommodate people where we're able to accommodate them, and it's not practical for us to seek to accommodate people near where accommodation lawyers cluster. That's a practical. That is a logistical challenge, but everyone has the right to legal representation. Certainly, we would not do anything to prevent people having access to legal representation.
I mean, it's a right, but it's difficult to exercise that right.
I mean, I don't know what you're.
I'm happy to move on to
Well, I'm not sure what point. I'm not sure what point you're making. I'm genuinely not sure what point you're
having
making.
the right to do something, but not having the availability of a lawyer to exercise that.
Lawyers travel. I mean, immigration lawyers travel, and I mean, the Bibby Stockholm has around 300 people. So there is clearly a market there for immigration lawyers, and immigration lawyers should be willing to travel, surely. Unless you're suggesting that we only accommodate people where there are clusters of immigration lawyers.
It's a practical consideration the government has not taken into account when placing people on a vessel so far away from legal support.
So is your suggestion that we only accommodate people where there are clusters of immigration lawyers?
I think it's something that you've not taken into account. Would that be fair to say?
No, it wouldn't be fair to say.
Okay, well, I'd like to see if you have any evidence for what you take into account when you decide to people.
No, hang on, you're making the assertion, so the burden of evidence is on you rather than me. I mean,
I think, Home Secretary, we're getting into kind of a debate here. It's quite clear there is a shortage of immigration lawyers in this country. That is well known. If you speak to the chair of the Select Committee on Justice, he would concur with that. So there is a problem with getting legal advice and immigration advice. Alison Tulis, I'm sure you want to move on to something else.
Thank you, Chair. Can I ask, have you yet carried out an equality impact assessment on the visa thresholds decision?
So on all government decisions, of course, we look at the equality impact. It is part of the process for all government decision making.
It's not been published yet.
We don't always publish all of the things that underpin our decision making.
Because it has been pointed out by various organisations that there is an equality impact assessment on this because women generally may earn less than men. That's a documented fact, unfortunately, and there will be a disproportionate impact, therefore, if you raise the visa threshold on women.
Look, as I say, we do take into consideration equality impact assessments. The equality impact that is part of the decision making that we have. There are a certain number of tools at our disposal. Those are the things that we can adjust in order to adjust the numbers of people coming through. It is not automatically the case that if something has a disproportionate impact, it cannot be put in place by the government. We just need to have due consideration to it. And I can assure the committee that we always pay due consideration to equality impacts. But the bottom line is that the numbers of people coming to the UK through the routes that we have sought to change, or we are in the process of changing, have significantly been above the levels that were envisaged, and the government, and indeed this has been mirrored by the opposition front bench, the official opposition front bench, is that the overall figures are too high and need to be brought down.
Is it fair that if somebody moves abroad for work, gets married, that they can't afford to bring back their spouse to live in the UK under these thresholds?
Well, we've always had thresholds for a significant
You're putting them up significantly. Is it fair that somebody in that
we haven't put them up for
circumstance?
20 years. We hadn't put them up for the best part of 20 years. Over a decade. Yeah. Over a decade. We haven't put them up for over a decade. There have always been thresholds. And whilst I completely understand there will be arguments for and against any particular threshold, the point is that we committed to reduce the overall numbers. We have made it clear that we're going to change the threshold. We've given a timeline as to when those thresholds are going to be changed.
Is it fair that if somebody moves abroad for work, falls in love, gets married, that they can't now afford to bring their spouse back to the UK to live?
Well, it's no more or less fair than it's ever been. There's always been thresholds.
That's now higher, so it's more unfair.
Well, that's your interpretation. I mean, I don't agree with your interpretation of it.
Is it fair that a care worker who comes here on that particular visa as a health and social care worker can bring their spouse and family, but a nurse who is living here, working here, can't now bring their spouse from overseas to come and live here?
And look, one of the things that we have done is sort to tighten up the rules around care workers and the health and social care visa, because we have seen a significant number of dependents brought through. I recognise the frustration implicit in your question that some people will have, which is why we're taking action to tighten the numbers of people who are coming through as dependents.
Is it fair that universities will now struggle to employ postdoctoral staff, postdoctoral researchers in their universities, because most of them will earn underneath that threshold? And what impact will that have on the university sector?
So I've not yet seen evidence that prediction is actually playing out, and it seems from the initial figures, and I'm conscious that it is very, very early, that the quantum of applications is still in keeping with the quantum prior to the changes that are being made, that we are putting in place.
The kind of rough salaries for postdocs are 30 to 36k. If this goes up to 38,700, they will fall under that threshold, won't they? Mm. What impact that will have on the university sector in the UK and the quality of research being carried out in the UK?
Well, what it will mean is that some people who might think of coming here will need to consider the implications of that. But the UK is still a hugely attractive place for the brightest researchers of the world. The quantum of people who will seek to apply, potentially, the potential market is still massive. And as I say, the average threshold that you discussed is just a little under the threshold that will ultimately put in place when we finish the transition from where we are to where we'll need to be. And whilst I do hear the concerns raised by the higher education sector, it is speculative, the impact. And certainly when I was foreign sector and I spoke, when I went to countries like India, for example, who have a very, very high interest in the UK higher education sector, the quantum of single people who would fall into the cohort of people that might want to come for postgraduate research, doctoral research, etc., is still massive. The potential pool of people is still many, many, many hundreds of thousands just from India.
Secretary, I'm just very conscious that it's getting near to 11:30, and I just wondered, Alison, I'm sure you've got some more questions, but could we just have more succinct answers, I think, and then we can get through, because we've still got to hear from Kim Johnson. That's all right.
I'm trying to give the best answer.
No criticism at all. It's just that I'm just conscious of your time, and we've got Prime Minister's questions at 12, so I just want to make sure everyone has a chance to ask questions.
Thank you.
Moving on, what is the safe and legal route for people to come to the UK from Sudan?
It depends on their individual circumstances.
And the individual circumstances are the visa application centre is closed, and I have a dozen constituents who can't leave Sudan and can't get here because their paperwork's at the VAC.
Right. Well, we put in place provisions for emergency travel documents. Again, without individual circumstances, it will be impossible for me to give complete answers.
I have a gentleman who has been waiting now since before the visa application centre was closed in March, April time to get his wife over. If the Home Office had been more efficient in its processing, she would be here now rather than being shot in the leg and waiting to get here. I also have a woman who's waiting, Kaltuma, who 3 of her children have been killed, and she wants to get her husband and her 2 remaining children to come over here. when will their visa be processed? She has been waiting for over a year, and my office has been back and forth to the Home Office with it.
Well, look, I'm not able to do casework
I appreciate
at a select
that, and
committee.
I'm not asking you to do that right here. I'm asking what is the route for people stuck in Sudan to get here?
As I say, it depends on their individual circumstances. You've raised individual pieces of casework. If they're with the department already, I will seek to get follow-up. If they're not, I mean, please, in your capacity as a constituency MP, raise these with the department.
Thank you. Kim Johnson.
Thank you, Chair, and good morning, panel. I've got a couple of questions for the Permanent Secretary and possibly Mr Dobbs. I just want to pick up on an early question about your aid reports and data. The Children's Commission has been waiting for data on unaccompanied asylum-seeking children. So do you know how many are currently living in hotels? And can you tell us how data is collected on these children?
Yes. With regard to how data is collected, obviously there's... Sorry, I'll take your first point first. There are currently no children, unaccompanied asylum-seeking children, being accommodated in hotels. We recognise the concerns that the committee have previously raised. We've gone through a process, and as of my appearance here today, there are now none. In that category. So remind me of the second part of your question about how you
collect data.
How we collect data. That's a bit more technical. Could I?
So we collect data at the point of arrival, and then we work closely with the relevant local authorities, which is quite often Kent, obviously, and then with whichever local authorities are taking on responsibility for each child, and then we aggregate that and publish it in the usual way.
Would you say that the process for age assessment undertaken by the Home Office is currently fit for purpose?
Well, yes, as much as any age assessment can be. I mean, it is. It is a universal truth that having a scientifically accurate means of assessing ages is incredible. Is incredible. I mean, no one has got one. We have a kind of a double lock process where assessment is made by two caseworkers. If either of them believe the individual to be a child, they are treated as a child. It is look, there is no absolute foolproof system, and it is very difficult. And of course, we do have a responsibility to make sure that children are dealt with appropriately as children. We also have a responsibility in terms of our safeguarding to make sure people who are actually adults are not accommodated with children. And that is a tension, and we recognise that as a tension, but it's one that we take very, very seriously.
Can I just ask in terms of what training caseworkers are given to do this level of assessments? Is it just stick a finger in the air and say whether they are an adult or a child?
No, of course, no.
So what training do they get then?
Again, oh, sorry, go on.
So first of all, the Supreme Court has deemed the current process lawful, and secondly, we are seeking to strengthen it by bringing in this National Age Assessment Board, which will allow social worker experts to come into the system and add to it. But the two separate independent people who have to make each judgment in the cases where it is contested are fully trained.
Moving on to Windrush, in 2019, your estimated 15,000 people would be eligible for the compensation scheme, but to date only 2,076 have received compensation. Can you just explain why it's taken so long and some of the discrepancies?
Well, that initial number was speculative. It was a rough assessment of the order of magnitude that we might need to. Of the people that we would need to support. In terms of the number of claims received, there have been 7,534 claims that have been received, and 2,076 of those claims have received an award totaling £75 million. And there are a number of claims which are still outstanding, 1,580 claims which are still work in progress.
How many people are working on that scheme, Home Secretary?
I will need to double check on that.
From memory, it's 250. It's about that. If that's very inaccurate, we'll get back to you. I think it's about 250.
Because there's been lots of complaints that the process is very bureaucratic and the form filling is very difficult. Are you taking anything on board in terms of simplifying the process?
We are, and thank you to this committee for your feedback after your visit to that team in Sheffield. We've had other feedback as well, and we have very significantly accelerated the decision making, first of all by increasing the number of caseworkers, and secondly by streamlining the requirements. So, for instance, the initial phase, which was taking 18 months, is now down to 4 months. We are very conscious, as we have talked about here before, that this is an ageing cohort, and they have been very unjustly treated, and the whole point of the compensation scheme is to help to redress that. And of course there's lots of other activity to make sure that a scandal such as Windrush can never happen again.
Just quickly on Windrush, as you said, people are very concerned about the delays because this is an ageing cohort. You will have heard almost everybody engaged in the Windrush issue has said that it should be moved from the Home Office to an independent organisation, partly because people believe it would be dealt with more efficiently without the delays, and secondly, that cohort of people, because of the way they've been treated by the Home Office, it's very difficult for them to come forward.
I really do understand that. I really do understand that.
It was also a recommendation of the committee as well that it should move.
And I get that. So I'm not necessarily convinced that moving this process at this stage of the process would speed it up. I totally get there is a deficit in terms of confidence of the Home Office. I totally get that, and I get that may have an influence on how people apply, and the cohort of people by definition are not people who start with a great deal of confidence in the department. I get that, and there is a difficult balancing act.
Okay, I'm going to come back to Kim.
Yeah, sorry, go on.
Does the Home Office still have dedicated teams working on the different resettlement schemes? And if so, how widely spread are staff in those different teams? Because we know that Afghan refugees have been having difficulty, getting accommodation and getting support.
Can I turn to you on
Yeah,
that?
so we have both policy and caseworking teams who manage all the various different resettlement programs we have. There'll be different ones for the Ukraine scheme and Afghan, but all Afghans who are brought into the country are given accommodation and support on arrival and their status under our resettlement schemes. We know that some people have been housed in temporary bridging accommodation because there isn't the availability with local authorities, but the teams are working through that both with local agencies and with local authorities to move people through. But there are dedicated teams for caseworking these programmes. As you'll know, we are doing a consultation with local authorities on what their capacity is to support safe and legal routes, so that we are able to ensure that our commitments on safe and legal can be met by local authority, housing and support.
If I could just add one thing, Ms Johnson, we are trying to do two things at once with the caseworking teams. First of all, we are trying to create a single, if you like, family of caseworkers so that you can have a career within caseworking within the Home Office, and you can get progression, you can get a very rewarding career that way. And so having some flexibility between different routes, different types of caseworking is an important part of that offer to our employees. But secondly, we recognise that there is benefit in expertise, and there is benefit in having a highly motivated workforce who really know and care about a particular cohort. So that is why we have given some teams and some locations particular responsibilities for some cohorts. But I think they would recognise that they are flexible, and that as the demand changes, they could move on to other cohorts.
But you will be aware that there has been criticism about the level of support in terms of Ukrainian settlement schemes and Afghan settlement schemes, in terms of the Homes for Ukraine scheme and all of those kind of things. So the schemes have not been equitable, and that there has been some criticism about that.
I do recognise that. I think one of the challenges comparing different schemes is that they are, whilst broadly seeking to do a similar thing, they are quite discrete and importantly different. So, for example, the Home for Ukraine's scheme, the accommodation scheme around that, because of the temporary nature, because of the desire to stabilise the situation in Ukraine or in enough of Ukraine that those Ukrainian families could go back home, and that's what they keep telling us they ultimately want to do, meant that it was going to be temporary in nature, and then the nature of the accommodation reflects that temporary status. The situation with the Afghan resettlement is it is a resettlement scheme rather than a temporary accommodation scheme, so the need for more permanent accommodation is different. So as Sir Matthew said, there's work that is common to both, and the teams working on it need to be able to flex across various, because the next thing we have to do, and we don't know what it's going to be, none of us can know what it's going to be, the next thing that we are going to have to do in terms of casework might be, once again, very different to either the Ukraine situation or the Afghan situation.
My final question,
sure.
Home Secretary, you mentioned earlier about being careful with words. It'll be true to say that you weren't very careful with your words in December in terms of the offensive joke. So how do you expect people to trust you in terms of dealing with the spiking challenge?
Well, look, the point I made, that I've made in response to that was, I'm annoyed with myself. For the record, I was trying to make an ironic joke because I was making the point, I was drawing attention to the point that I had put forward legislation that day, tightening spiking, and that, and look, again, in the same way that I talked about having been involved in policing professional standards since the beginning of my time in politics, the protection of women and girls is one of these things I've worked on throughout my career. I took action on spiking as one of the early decisions that I've made. Prior to my time as Home Secretary, I drove through the Women and Girls Strategy at the FCDO to make sure that all of our international aid, 80% of our international aid had demonstrably positive effect for women and girls. So the comments that I made, of course I regret, and I apologise, and that apology is heartfelt. I'm frustrated if in any way it's detracted from, I know it will have detracted from the work that we're doing. I am, however, absolutely undeterred that I will continue pushing to improve the safety of women and girls. I hope that I'm judged on my record, and I'm conscious that I now have an enhanced duty to prove my credentials on this. That's down to me. No one else's fault. That's down to me. But the way I respond to that is making sure that at some point in the future, when people look back and they are rightly frustrated with what I said in December, they will balance that against my actual record of delivery, both beforehand and since.
Well, actions will speak louder.
Yeah, absolutely. I think it's fair point.
Thank you there, my question.
Obviously, this trip to the dentist has been quite a sort of general check-up on a number of issues.
With molars, incisors.
We haven't been able to cover everything. I just wondered if you might be able to write to me with some questions we haven't got to ask today. We don't have time to go through. So just going back to Kim Johnson's point about the information the Children's Commissioner requested in April 2023, when will that be provided in full? Because there's still information outstanding. And then perhaps, Sir Matthew, you might be able to write to the committee on the point of if a civil servant refuses to follow a ministerial direction not to comply with the Rule 39 indication, what action will be taken? Perhaps you could write to us about that. We've had correspondence from, I think, the Cabinet Secretary about this, and I think your response to him. But we would welcome your understanding of what would happen to an official in those circumstances. Can I also just raise a few other things? We're very pleased to see the number of caseworkers that the Home Office now has, and that's obviously contributed to the backlog being dealt with. Could we please have the retention rates for those caseworkers? Because we know that's been a big problem in the past, and we'd like to see if progress has been made on that. Could you also confirm whether, in preparation for the Rwanda scheme, you do now have an airline that is willing to take people to Rwanda? because I know in the past that's not been the case. Could we also know how many empty hotel rooms you're currently paying for in terms of the asylum accommodation? I think the last time we heard it was about 10,000 empty hotel rooms that were being commissioned by the Home Office.
Yeah.
So if we could have that information, unless you'd like to correct us now.
No, I was just checking to make sure, because one of the things that I want to make sure is that in our kind of regular reporting cycles, that we have completeness of reporting. So if there's things that have been gappy, I want to see if we can address those gaps, but I'll make sure that
Thank you. And then I've been asked to put to you, why has the government not produced a hate crime action plan in 5 years? Now, we're particularly concerned with that because we've been doing an inquiry into policing of protests, and there are the many issues that have arisen around hate crime. So could we have a response on that and where the government is on looking to produce a new hate crime action plan? I think it was supposed to be reviewed in 2018.
There's certainly been a lot of action on how to respond to hate crime and a lot of work with police on that. I'm absolutely sure we could write with an update on
we want to know where the plan is.
Yes.
I mean, things have moved on in 5 years and there hasn't been one. And the only other thing I just wanted to ask you, Home Secretary, was about Wethersfield, and obviously that's in your constituency, and you've indicated in the past that I think you take the view it shouldn't carry on for very long, it should be closed. Is that correct?
Well, so the broad point that I've made is that, so firstly I'll make it clear that I've recused myself from operational decisions around Wethersfield. And that function is taken up by another minister in the department, so that there is no perception of conflict of interest. First point. So the thing I said about its location prior to its opening are a matter of record. But what I have said is ultimately I want to reduce the need for asylum accommodation in general. And the point that I've said, and I've said this to both my constituents and more broadly, that the cost of asylum accommodation is far too high. I want to speed up the processing of asylum claims so that we do not need that quantum of accommodation. And ultimately what I want to do is make facilities, whether it be the Bibby Stockholm or Wethersfield or hotels, I want to make them obsolete because we are processing more quickly.
Well, I think we're all agreed we want you to process more quickly, absolutely. The very final point about the Brook House public inquiry and the report that's with the Home Office, will you be responding within the 6 months that the Chair had requested?
Yes, we will.
You will, so within 6 months you'll produce the report?
Deadline's taking us. The response. Yeah.
Yes. Okay. Thank you very much. And can I thank you for your time and for we've run over slightly, but thank you very much. That's been very helpful. Thank you. Thank you.
The proceeding has ended.